Dear students, dear guests, welcome to our joint seminar, Peace and Conflict at Global Level, Contemporary Issues. This course is a partnership between the Global Awareness Education at the University of Tübingen in Germany and the Federal University of ABC, Brazil. In this course, we discuss the contemporary tools to conflict management, resolution, and transformation used to promote peace, discussing concrete cases and different perspectives from around the world. We had guests from different countries and contexts, and all contributed with lectures. And students also are going to do some group work. In both universities, the course is offered to students from different disciplines, in Tübingen as part of the Global Awareness Education in the Transdisciplinary Course Program, and as a free extension course at the Federal University of ABC. The course organizers are Professor Gilberto Rodrigues, Federal University of ABC, Hassan Tahiru, and me, Rosa Pérez da Silva, from the University of Tübingen. So today we are going to hear a lecture on the role of international law in conflict prevention with Professor Patrícia Galvão Teles from Portugal. And I would like to ask my colleague, Gilberto, to introduce our guest.
Good morning, good afternoon for everyone. My name is Gilberto Rodrigues. I'm Associate Professor at the Federal University of ABC, and it's a great pleasure to welcome Professor Patrícia Galvão Teles, and I'd like to introduce her to the audience. Professor Patrícia Galvão Teles is currently member of the United Nations International Law Commission. For those who are not familiar with this UN branch, the Charter of the UN has a provision creating the International Law Commission, which is the most important branch at the UN to discuss and to contribute to the codification and the progressive development of the international law. Professor Galvão Teles was elected in 2016 for a first mandate, and then she was re-elected for a second mandate. The election is held by the General Assembly of the United Nations. So all the countries, members of the member countries of the UN, vote for this election. So this is one thing very important to stress to you about her curriculum. She is also professor of international law at the Autonomous University of Lisbon for many years. And finally, she is a senior legal consultant on international law at the legal department of the Portuguese Ministry of Foreign Affairs. So Professor Galvão Teles, as you can see, she holds a official position at the Ministry of Foreign Affairs, and for us it's a privilege to have you here, Patrícia, and for me personally, it's a great pleasure because we have been in touch for many years, and it's our pleasure on behalf of the course to have you to talking about a so important issue, which is the role of international law in conflict prevention. So the floor is yours. Thank you very much.
Thank you so much, Professor Gilberto Rodrigues, and thank you also, dear Professor Glaucia Pérez da Silva, and also Luisa Fernandes for assisting in this class. I have to say that the privilege is mine, Gilberto. It's very good to have been keeping in touch after so many years that we met in Geneva at the International Law Commission, precisely when we were both young students, and we attended the seminar that is organized every year by the International Law Commission. It's always a pleasure talking to students from all over the world, and I'll do my best to address this topic that was allocated to me on international law and the role of international law and conflict prevention. I'm told by the organizers that it's a mixed group in terms of background, so I'll try to explain a little bit about the relations between international law and the important issue of conflict prevention. And I'll be very happy also then in the discussion part to answer any questions that you may have related to the topic, or also related to the work of the International Law Commission that, as Gilberto explained, is a body of the United Nations that has the role of preparing drafts of codification and progressive development of international law. And in the past, it has worked on many issues that you're probably familiar with, like law of treaties or diplomatic and consular relations, having done the initial work to what became then the famous Vienna Conventions on Law of Treaties, or the Vienna Conventions on Diplomatic Relations and Consular Relations. But I'll be happy to talk about that if you're interested a little bit later. And I will touch on an issue that we're currently working on during my talk. So I thought I would start by speaking to you a little bit about what I think is the role of international law in conflict prevention. And then in a second moment, using two examples to illustrate that role. You've been distributed some materials that are related to a recent debate that happened in the Security Council on the issue of the rule of law. This was a debate in January this year, organized by Japan, who at the moment was a non-permanent member of the Security Council. And I wanted to use that as an example of the links between international law and the rule of law, and the maintenance of peace and security, and in particular, conflict prevention. And so I thought it would be more interesting, rather than giving you just academic literature, for you to read something from practice, from what states say, where the states see those links between the role of international law and conflict prevention. As I think you saw from how Gilberto presented me, I'm a mix of an academic but also a practitioner, and so I always like to tackle issues also from that point of view. And I think for students that are not just lawyers, it's probably also more interesting. So I will use that example of the debate in the Security Council on the rule of law to illustrate the links that we can have between international law and conflict prevention. And I will also use another example that I didn't send you reading materials, but I'm happy to provide references afterwards, because I thought maybe it was too ambitious to give you too much reading material. But it's actually another debate in the Security Council that happened only 1 month later, so in February this year, on sea level rise and threats to international peace and security. And this is, to show you clearly that, from the point of view of the Security Council, that is the organ of the United Nations that I think by now the main organ that has the primary responsibility for the maintenance of peace and security. And so, of course, very important also in the conflict prevention area, not just the reaction to conflict, but also the conflict prevention. Not only more traditional threats like the traditional conflicts, wars, civil wars, wars between two countries, are threats to international peace and security that need to be incorporated when we think about conflict prevention, but also less traditional threats like climate change, and in particular sea level rise, which is one of the adverse impacts of climate change, can also be seen as a threat to peace and security, and how the Security Council is dealing with it. So it's quite curious that in the first half of 2003, we've had these two debates, just 1 month apart, one in January, the one that I sent you the materials, but also one in the month of February, organized this time by Malta, that has the rotating presidency. I'm not sure how familiar you are with how the Security Council is organized, but you have the permanent members and the non-permanent members, and they each hold presidency for a month during the year. And so Japan had the presidency in January, and normally it's the country that holds the presidency that promotes this thematic debates. And so we had Japan on the debate on the rule of law, and then in February, Malta promoting a debate on sea level rise and the threats to international peace and security. And so I wanted with this to illustrate the role of international law in conflict prevention when we talk about traditional threats. And for example, we can think of the obvious example now, which is the conflict between Russia and Ukraine. But we can also think about, how can we use international law in conflict prevention, also when it comes to non-traditional threats like climate change. And with regard to this last one, and that's where I said there would be a link also with regard to the work that we're currently doing at the International Law Commission, because actually the International Law Commission is now working on the topic of sea level rise. And in this topic, trying to discuss the legal issues that are prompted by this adverse impact of climate change, and what responses can we find in international law to minimize the impact that we know are happening and will continue to happen. I'll speak a little bit more about that in a moment. To explain how international law can also be used in that sense to minimize the impacts and to have a legal framework to address the issues, and with that indirectly working towards conflict prevention. And it's the nexus between climate and security has been quite evident in several debates in the Security Council. So let me try to go step by step, initially speaking a little bit, because I know we have a lot of non-lawyers and non-international lawyers, speaking a little bit about international law, and then looking at how can international law contribute to conflict prevention when it comes to more traditional conflicts, and using that debate in the Security Council on the rule of law, and then conflict prevention of created by less traditional threats, challenges like climate change. I think that one thing that needs to be emphasized, and in the diplomatic world, it's often said that international law is a common language between the different countries. And I think that that idea is quite important one to explain the potential role of international law in addressing conflict. We know that countries sometimes are not in the best terms. Sometimes there's situations like, for example, the one that we lived during the Cold War, that nowadays is, always recalled, also because of the different situation we're in today, but that may have some points of contact with the big rivalry between 2 or 3 main powers. And so there's a lot of discussion today about whether we're living a new Cold War. Some people say it's a hot peace. I like that expression because, we have certainly, a very difficult period for international relations at the moment, where things are changing. We don't know yet the direction, but we see, different positions, even with regard to international law. So I think one of the interesting points and the strong ideas to explore is that despite political, military, strategic rivalry, international law is seen and should be seen as a common language between nations. So even when the things are difficult at the political level, there's tension, there's competition, there is a minimum a common denominator in terms of a set of rules accepted by everybody, and this set of rules, of course, it has a legal power, but it's also seen as the common language between the different countries. And that's important also because, especially in the last 75 years, almost 80 years now, so since the creation of United Nations, which is a relatively recent period in history, but where for the first time there is a permanent organization that has the potential to be universal, and indeed it's universal, and it has powers also that are much wider than its predecessor, the League of Nations. So it's really the last 75 to 80 years, the period in history where states have decided to have an organization where they can come to and discuss any issues from what is called the 3 pillars of the United Nations: development, peace and security, and human rights. And almost any question of international relations can fall on these 3 categories of development, peace and security, and human rights. And indeed, there's quite a strong link between these 3 pillars, whereby you can't have development without, peace and security, or without respect for human rights, and vice versa. So unique moment where you have an institution that now has nearly every country in the world, which is what was not the case when the UN was created, because when you think, and I was just reading that because yesterday, the 26th of June, it's the date where the UN Charter was signed in San Francisco, before the Charter became into force later in October. So the 26th of June, and yesterday there was some posts on social media reminding that it's always good to remind this is the day the Charter was signed. It was signed just by around 50 countries. Including Brazil, but not Portugal, for example, or not Germany, also for obvious reasons. But it was signed by 50 countries that at the time were relatively representative of the existing international community at the time. But now with the days when we think that the UN has 193 member states, it was quite a boom in membership, and of course a lot of it is due to decolonization, to the movement of decolonization, that, for example, I was just out of curiosity trying to check. I mean, in the founding members of the UN, you have 3 African states, South Africa, Liberia, and Ethiopia. And today the African group in the UN has 54 countries, 54 member states. So it's clearly, you know, because of decolonization that today we have the world more representative in terms of independent sovereign states, and that is reflected also in the composition of the United Nations. And one of the most important things that the Charter of the UN has given us, and also the work that was developed on the basis of the Charter, is the idea of common principles. So this idea of a common language, but also common principles of international law, the fundamental principles of international law that one finds in the UN Charter in Articles 1, 2, and also in a very important resolution that was adopted a little bit later in 1970, Resolution 2625, also known as the Friendly Relations Declaration, that develops the principles that were enshrined in the Charter, such as the principle of sovereignty. I think one cannot forget that sovereignty is still one of the main principles of international law, and with sovereignty, together with sovereignty, the principle of non-interference in the domestic affairs of other states. And those were certainly old principles. They were the ones that reflect better the Westphalian nature. So the idea of the sovereign state that is independent and equal at the international level. But the Charter also introduced some new principles that today are fundamental principles and accepted by fundamental principles, like the prohibition of the use of force and the principle of self-determination, or the principle of the protection and promotion of human rights. And so it's very interesting to see that today the international community has international law as a common language and with a common set of accepted principles that go from the most traditional ones like sovereignty and non-interference in internal affairs, but also to the prohibition of the use of force, self-determination, human rights, and one that is very important also for the purposes of our discussion, the peaceful settlement of international disputes, which is something that started being developed even before the prohibition of the use of force. When we think about the developments in the Hague conferences of 1899 and 1907, where the idea of a creation of a permanent court of arbitration, the idea of arbitration, and then with the League of Nations, the creation in 1919, after the First World War, the creation of a permanent court of international justice that then became, with the UN, the International Court of Justice. So when we speak about the International Court of Justice, that is the principal judicial organ of the United Nations. It had already a predecessor in the League of Nations with the permanent court. So an international institution, permanent justice has 100 years now, 100 years. So this idea of the peaceful settlement of disputes is extremely important when we think about conflict prevention, because conflict prevention is achieved and should be achieved by the means of peaceful settlement of disputes. So, of course, from negotiation to mediation, conciliation, good offices, but also to the judicial means, like the resort to the International Court of Justice, and arbitration. And nowadays, I mean, even specialized tribunals that we know exist, like ITLOS, the International Tribunal for the Law of the Sea, and of course, all these institutions have a very important role when it comes to conflict prevention, since they are means for states to settle their disputes in a peaceful way. So what we see today, and I think that's what I wanted to emphasize, especially having in mind that there are not a lot of specialists in law or international law, is that we have today, because of the UN Charter, a number of agreed fundamental principles, like the ones that I've mentioned. And they help to consolidate this idea of international law being a common language, providing common principles for states to speak, to negotiate, to go to court if necessary, in order to avoid conflict. And of course, with the very important rule that we've had for the past 75 years, that the use of force in international relations is prohibited by international law, except in the cases of self-defense, Article 51 of the Charter, or when the use of force is authorized under Chapter 7 by the Security Council. Of course, we can think that this architecture of the Charter, when it comes to the issues of peace and security, has some important deficiencies in the sense that peace and security, the maintenance of peace and security was attributed essentially to an organ, the Security Council, that has an inbuilt difficulty that, initially I think it was conceived for reasons that one can understand, and of course I'm happy to discuss that more at length in the discussion part. But I think you're probably all aware that when the Security Council was being designed, 5 members were designated as permanent members of the Security Council, and these 5 permanent members have a right or a duty. I think it's also a duty, but a lot of times exercised as a right that the other non-permanent members don't have, which is the veto power. And of course, when we look at the work of the Security Council during the Cold War, which really happened just as the ink that was of the pens that were used to sign the Charter on the 26th of June 1945, the Cold War started not so long after. And so from the beginning of the Cold War, throughout the whole period of the Cold War, but also in more recent times, the Security Council is often blocked and cannot exercise properly its functions as the main organ that is tasked with the maintenance of peace and security. And so the balance that one makes, of course, I think it's very important to emphasize this rule of international law as providing the common language, as providing common principles that states can use to avoid conflict, to avoid the escalation of conflict, to prevent conflict. And there are many means of peaceful settlement, including judicial means at the disposal of states. But when it comes to the political organs of the United Nations, with the Security Council as the main body, the system does not work in a perfect way because of the veto power. And we can discuss also, I mean, how much an alternative role can the General Assembly play in this regard. But of course, that is a bit of a departure of what was initially envisaged by the UN Charter. But so this is the main idea that I wanted you to have in terms of international law, in terms of conflict prevention and the potential of its role, especially this idea of common language and common principles. But so when we think about you know, the specific examples, and we said we would discuss two. One that is more related to traditional conflicts, and the other one by non-traditional threats like climate change and sea level rise. The debate, I think, talking about the first one, the debate in the Security Council that was promoted by Japan in January 2023, about the rule of law, about how can the promotion and the strengthening of the rule of law have also a role in the maintenance of peace and security. That for me it's also, I mean, although we see that there's often political blockage in the Security Council, this type of debates are very useful in understanding how, you know, states agree. They actually agree, and we see that in the different interventions of the different states in this, you know, very much participated debate. States in general, they agree on those principles, the consensus that was created by the Charter, and then, you know, reiterated in the Resolution 2625 of 1970, and in several other documents, important documents of the UN. Like, for example, there was a resolution in 2012 on the rule of law at the national and international level. And nowadays, there's a discussion that is very important to follow, promoted by the Secretary General of the United Nations on the topic, the theme that he called Our Common Agenda, which is an agenda of the Security Council for the, you know, reformation and strengthening of the United Nations. And he speaks in that in that report from the 75th session, and it's going to be, I think, then feeding into a process that will lead into a declaration next year, where there will be a summit on the of the future. It's called Summit of the Future, so very evocative name, where these ideas will be again reiterated of international law and also the rule of law, which is sometimes in the UN language another way of speaking about international law, the rule of law. There will be, you know, a reaffirmation of the commitment of states towards this common principle, shared vision of international law. Of course, that is not to say that, and I don't want to give that impression, quite to the contrary, that although states agree with these principles and they recognize them, you know, I always tell my students, I've never seen a state saying, well, we use force because there's no principle prohibiting the use of force. You never have that. You know, even in most extreme circumstances, you always have the recognition that there is a prohibition of the use of force. And so what you have in practice is states justifying on the basis of what they think is the available, the plausible, the adequate justification that they can undertake a certain commitment or a certain type of behavior that is not in violation of international law. So I think that's sometimes when I have skeptical students saying, well, international law is very weak, it doesn't exist, states disrespect it all the time. I always try to explain it in this sense. I mean, all states say that international law exists. We don't have, even the most isolated states, they do not deny the existence of the UN, of international law, they're members of the UN. What happens in practice is that you have, and from different political backgrounds or purposes or places in the world, you always have a very careful justification why a certain state thinks that they did not breach international law with a certain conduct, and not the negation of the principle. So I think that's the important point. So let me move now. I see time is moving fast. It's always going faster than we think. Let me just, briefly also add to this dimension an example that comes not from the traditional conflicts, but from new challenges, new types of conflicts, like what climate change can create. And of course, as I said, I'm quite interested on that since in the International Law Commission, I'm co-chairing the study group that is dealing with the issue of sea level rise. So it's one of the impacts of climate change. There are more, of course, desertification, drought, heat waves. I think we're going through one heat wave in Portugal at the moment. I don't know how it is in Tübingen, but in Lisbon, it's quite hot. But we have more and more heat waves. But let me concentrate on sea level rise. And it's quite interesting to note that the International Law Commission, which is normally a very traditional body, in terms of dealing with the very classical issues of international law, has been called there was a lot of support from member states to study the legal implications of this physical phenomena. So the idea that with global warming and emissions, the temperature of the oceans is warming, so the water is expanding, but also global warming is leading to the melting of the ice caps. And so with that, we have more water in the ocean. And so that leads to a rise in the mean sea level, which is more significant in some areas of the globe than others. And so it might be, bringing us some very difficult scenarios. And what scientists are saying, the IPCC, the Intergovernmental Panel on Climate Change, what they're saying is that even if today we met the goals of the Paris Agreement, sea level rise is locked in. So this is a physical phenomena that will continue. I don't know if you have seen that in the last couple of days, there have been a number of articles in The Guardian speaking about that. I mean, there's more and more also in the press. So this issue of, of course, sea level rise is only one aspect of climate change, but is one that will happen, and it's already happening and accelerating regardless of what countries do to mitigate climate change. And it's also one that has the potential to affect the three elements of the state, in the sense that states can lose territory, land territory, but with that also maritime territory. Population may need to move, because if you have water in places where before you had local coastal communities, and most of the world lives by the coast, by the ocean. So you may have those coastal communities that have to move to other places in the country, or they may have to migrate abroad. And so there's a lot of discussion whether there are climate refugees, if there's this category. But it can also, in the most extreme cases, with some islands in the Pacific and in the Caribbean, but mostly in the Pacific and the Indian Ocean, where the islands are very low. They're atoll islands, they're not volcanic islands. Some of these states may even disappear. So it may even affect the existence of some states. So it's only one of the impacts of climate change, but it's one that has quite important implications when we think about the traditional notion of the state, where you don't see that when we speak about heat wave or drought or desertification. But the thing is that this has never happened. A state has never disappeared. And so international law does not have the answers yet. But it's very interesting to link this to the discussions in the Security Council, and there have been a few of them, and this last one from February, organized by Malta, is very interesting because clearly states see, there's a couple that are a bit more conservative in the sense that they don't think that there's an immediate connection between climate change or sea level rise and conflicts or threats to peace and security. But most states, and I'm happy to send you then the documents also on this other, if you're interested. I didn't want to give you too many documents, but that there is a link between loss of territory, including maritime territory. Many of the states, for example, in the Pacific that are more exposed, they are what they like to call themselves large ocean states. So small territory, but huge exclusive economic zones, for example. So if those states, because of sea level rise, if they are deprived of a significant number of their own existing economic resources, because a small island where you used to count economic exclusive zone disappears, and then you have less resources for the country. If you have big movements of population within the country, that's also something that can bring about potential conflict. If you have and I'm talking a lot about the small islands in the Pacific, but you think, for example, countries with low-lying coasts like Bangladesh or Vietnam, and you start seeing big movements of population, and then you have less resources, then you have the fresh water lens becomes infused with the salt water, and then you have less water, you have less agriculture. Those are the fuel for conflict, and so not even thinking about the most extreme issue of a state disappearance, even just losing economic resources with the loss of economic exclusive zone or population movement, you can see the link between sea level rise and the potential for conflict, for threats to peace and security. So there's a clear link that the Security Council has recognized. And when you think about what we're doing in the International Law Commission, which is trying to, in a preventive way, not just reactive, because international law normally is reactive to events, to crises. We're trying before the big crisis happens to try to develop legal tools to make sure that the situation is more clear, more predictable. There's more legal certainty that states, for example, can anticipate some of the measures, for example, to avoid that their citizens become statelessness because they go to different countries, and the nationality laws may generate by chance, statelessness persons, by, for example, trying to have more international cooperation so that states can have pathways for migration that is regulated, and we don't have the chaos that happens with the irregular migration that then also generates the potential for conflict. So this is another example where you can see international law being used in a positive way, being used to try to prevent conflict by having more legal clarity, security, predictability, and basis for international cooperation.